salutati. Sì, ci siamo salutati. So, good morning everybody. I am here first of all to welcome and thank the speakers and the participants in this workshop. And on behalf, I have the task to excuse our dean, Professor Fulvio Cortese, who is committed to other issues and he cannot be present now, but he also welcomes and thanks you all. I also like to thank Dr. Francesca Mussi, who is the convener and the organizer of this workshop, and the groups of interest of the Società Italiana di Diritto Internazionale, the groups on international law and European law and human rights, and the group of international organizations that are co-patronizing this initiative. This initiative, as you know, is on the role of Africa's supranational courts in the protection of fundamental rights, contributions and challenges. And we have the pleasure of having here real experts on this issue. I will moderate, I will chair, I will moderate the workshop. But let me first of all say a few words on why we decided, Francesca together with me and the other colleagues of international law, why we decided to have this workshop on Africa and human rights. Our law school has been committed since many years, I would say, to study the issue of human rights in different perspectives and in different contexts. Last October, we organized a meeting on something that is lacking in Italy, the National Authority on Human Rights. And also on that occasion, there were important contributions by experts on this issue, trying to find a way from the scientific point of view to set up something that is really needed, in our opinion, in Italy. But since human rights is one of our main field of study, we also thought that going back to Africa and going back to the protection of human rights in Africa was also a very important topic for many reasons, but also because our faculty, our law school, has been committed in the last 2 years, I would say, to set up a project on the protection of human rights in Africa, and especially in the Somali context. In this regard, we thought it would have been wise to organize this workshop, looking at what has happened in the last 40 years in Africa in the protection of human rights, even more, I say, in the last 50 years, and especially what has happened in more recent years at the continental and at the sub-regional level. Because there are some novelties that maybe are not known by everybody. And this is the reason why we thought that we had to think about what have been the developments in recent years, starting from the Organization of African Unity in the 60s, but also through the various steps that have been, I would say, accomplished in this field by the African Union and also by sub-regional organizations. The steps that have been accomplished, but also those that have not been accomplished in this context. I don't want to bother you now because I am eager to understand how our speakers are going to address these issues. My task is that of saying just a few words on the structure of the workshop. As you see, we will have a first session on the setting of the main features of the protection of human rights in Africa. In this first session, Professor Senonjo and Mr. Apollin Zuapet will talk respectively on decolonizing human rights and African perspective and the puzzling African human rights system, who should do what. I will introduce our guest. Professor Senonjo is Professor of International Law and Human Rights at the Brunel University, London, where he teaches human rights law, international criminal law, international trade law. He has written extensively on human rights protection in Africa and has authored a monograph titled Economic, Social and Cultural Rights in International Law. Mr. Apollin Zuapet is a PhD candidate in international law at the University of Geneva. He also obtained the diploma of the Hague Academy of International Law. He will soon defend his thesis on les immunités de l'ordre juridique international, les prismes de la constance. And he also is the author of a book on la recevabilité des requêtes devant la Cour de justice de la CEMAC, contribution à l'analyse des conditions d'exercice de la fonction juridictionnelle devant les juridictions communautaires en Afrique centrale. I will say that we can start with this first session. And if I will ask the speakers to intervene for no more than 20 minutes. And if there is time, we will have a short Q&A after it. And then we will have a break. And I will go ahead with the second session. Okay? So, Professor Senonjo, you have the floor.
Thank you very much for organizing this conference and for inviting me and offering me the opportunity to talk about decolonizing human rights. May someone please assist me with a PowerPoint? I have some few slides here.
Maybe we can start.
So the topic is decolonizing human rights, an African perspective. That gives rise to a number of questions. What are human rights in the first place? Are human rights colonial? If they are not colonial, we can't decolonize them. What is colonial within human rights that requires decolonization? And in that context, what has been the role of African regional institutions, in particular, the African Commission on Human and People's Rights and the African Court on Human and People's Rights. Thank you. By way of context, I'll begin by, can we remove this, please? Okay. Yeah. By setting out the historical context, so that you can understand the context within which this discussion could be discussed. Then talk about the link between human rights and colonialism. And then finally, I would quite very briefly go through some of the work which has been done by the African Commission in particular, and what could be the future work that could be done by the African Court on Human, by the African Court of Justice and Human and People's Rights. I guess it is not news to anyone here that Africa as a continent has experienced serious violations of human rights in several forms. slavery through transatlantic slave trade, followed by a longer period of colonialism and new forms of colonialism after the so-called independence. Practices like apartheid in South Africa, and all those have contributed to conditions which are favorable for violating human rights, including poverty. When you look at the list of the least developed countries in the world, predominantly, you'll find a number of African states. Out of about 45 states, nearly 30 of them are in sub-Saharan Africa. And that's not accidental. It's a result of a wide range of factors, including that injustice experienced historically, which unfortunately has not yet been addressed. So a theoretical question, what do we mean by human rights? The number of human rights experts here, but the concept of human rights in general is contested, meaning that human rights could mean different things to different people in a different context. For example, the primary document for protection of human rights in Africa is known as the African Charter on Human and People's Rights. When you compare the text to the European Convention on Human Rights, you'll find significant differences when both documents claim to protect human rights. So theoretically, over a period of time, the theory of human rights has been moving from conceiving human rights as natural, as given, as inherent, to conceiving them as human rights which are agreed upon. States discuss, come together at a regional level. They discuss and agree what should and what should not be a right and in which context. To what extent would it be limited? So they define the scope of rights. In a state-based system, states significantly influence the content and therefore the practical definition of what human rights are. But at a more general level, human rights may entail the so-called civil and political rights, economic, social, and cultural rights, and both rights could be enjoyed as individual rights by you, by myself, or as collective rights by groups such as minorities or indigenous peoples. The actual content then would depend on the situation prevailing in a particular continent when it comes to agreeing as to what are human rights in a regional document. We could summarize all that by saying that human rights are set for struggle against abuse of power in all its forms. When you protect my right to freedom of movement, or access to health care, or adequate food, or social security, the theory is that this right is exercised against certain dominant entities, the state, it could be non-state actors, and in one way or another, they exercise power, and that power could impact negatively or positively on one's right. So it's a continuous struggle ongoing to define what are and what are not human rights. In that process, human rights could be used for different purposes, including liberation or even colonization, as I'm going to show. So what then is colonialism? I would not go very deep into the history of colonialism. It would suffice to stress that in 1960, in the Declaration on Independence for Colonial Countries and Peoples, the General Assembly stressed the need for a speedy and unconditional end of colonialism in all its forms and manifestations. So since 1960s, there is an agreement at a universal level that colonialism must end in all its forms, whether hidden or whether it is quite manifest that one, for example, an imperial power is exercising control over another group which is dominated. And the term in itself refers to subjection of peoples to alien subjugation, domination, and exploitation. So what is key about colonialism is domination and exploitation. That domination and exploitation could come from different sources, not necessarily imperial powers. It could be exercised at a domestic level by domestic elites who are manning a state power itself at different levels, whether executive, whether legislative, or at a judicial level. So in that sense, although colonialism historically referred to a colonial power exercising control of a colonial territory, like, for example, Britain in Kenya, it may also be exercised by a group or groups in a state in such a way that another group is subjected to domination. For example, men may dominate women in a particular state. They define what rights women may be entitled to and what rights could be violated. They may decide to violate rights of minorities, ethnic, racial, national. They may decide not to respect rights of indigenous peoples. All those are forms and manifestations of exercising power in an abusive way and could therefore fall within a general understanding of colonialism. That brings us to the crux of the matter. Do human rights need colonizing? The theory, as most of you may be aware, is that human rights are universal. They are indivisible, interdependent, interrelated. That is justified on the basis that we all have inherent human dignity. We are equal at birth. In that respect, the rights we enjoy here in Italy should be the same rights someone is enjoying in Mali. That is the theory. In practice, conditions of universality are far from being realized. So certain groups, certain individuals do not enjoy human rights. They are excluded. In that sense, there are certain dominant groups exercising control, domination over certain other groups. That means then we need to decolonize human rights in the sense of ensuring that those who are excluded, those who are marginal, those who are disadvantaged, also enjoy human rights. You may be enjoying university education here, but in several parts of the world, children cannot even complete primary education. And that is a result of so many factors, some of which are beyond the control of a particular state. Human rights were used, for example, as part of the civilizing mission during colonialism. So you can colonize a particular territory in order to civilize them so that they can enjoy their rights. You can educate them. So you justify, in that respect, that's an example of how one could use human rights to justify colonial domination. That means that the concept of human rights could be misappropriated. It could be manipulated to oppress, to demean, and undermine the dignity of marginalized and excluded individuals and groups, particularly from decision making. But that does not mean that the concept itself is inherently colonial. It's simply that it depends on who is using it. We can use human rights, for example, as a means of liberating ourselves. I give an example here of the right to self-determination. This is one of the key rights protected in the UN Charter, the equality of rights and self-determination of peoples. That is Article 1.2. It's one of the purposes of the United Nations. At the very beginning of the UN Charter, respect for the principle of equal rights and self-determination of the peoples. It is also repeated in Article 55 of the UN Charter, the principle of equality and self-determination of the peoples. And it is common Article 1 of the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights. The definition being that self-determination would allow peoples to determine their political status, freedom from colonialism, to pursue their economic, their social, and cultural development. So that norm is already there in international law, meaning that international law and international human rights in particular could be used to decolonize human rights, could be used as a means to ensure that all peoples anywhere in the world can determine their political status. They can pursue their economic, social, and cultural development. And that would translate into enjoying civil and political rights, as well as economic, social, and cultural rights by even groups which are marginalized. More specifically in the African context, the African Charter refers specifically to the need to eradicate colonialism in all its forms, and it also protects specifically the concept of people's rights. Just some bit of history. In 1963, the Organization of African Unity was formed, and one of its objectives was to bring an end to colonialism and apartheid in Africa. It adopted the African Charter on Human and People's Rights in 1981, which entered into force in 1986, and the Charter protected a wider range of rights, including the right to self-determination. When it was replaced by the African Union in the year 2000, the African Union in its Article 3 refers to the objective of protecting human and people's rights in accordance with the African Charter, which includes the right to self-determination, and also other relevant human rights instruments, which includes instruments which are universal, such as the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights, even the UN Charter. That's why I'm referring to them. So there is a basis for applying universal human rights derived from the African Charter itself. So the preamble of the Charter refers to the need for total liberation of Africa from colonialism. To what extent has Africa been totally protected from colonialism? By 1960s, most colonial powers had left Africa, but there are new forms of domination, and I will end by talking about those quite very briefly. In Article 20 of the African Charter, it restates the right to self-determination. And more specifically, unlike the international covenants, it refers specifically to the rights of colonized or oppressed people to free themselves from bonds of domination. So the Charter empowers oppressed peoples in Africa to free themselves from bonds of domination, regardless of where it emanates from. Whether it's from domestic elites, like happened recently in Algeria, or Sudan, or Zimbabwe itself. One can look at that. When people are oppressed, they can peacefully resist against undemocratic regimes in order to free themselves from bonds of domination, and the Charter entitles them to the right to assistance. So other states parties, other African states, and the international community as a whole could provide necessary assistance to free peoples from bonds of domination. By freeing peoples from bonds of domination, human rights are being decolonized so that those who are excluded and marginal could, if circumstances permit, and if right tools have been used, assert also their rights. They could, at the very minimum, participate in decision-making in which they've been excluded. How can peoples exercise their right to self-determination in order to decolonize all forms of domination? The African Commission has stated there are so many methods, which could include independence, self-government, local government, all those other methods as listed there in accordance with the wishes of the people, but that is subject to state sovereignty and territorial integrity of the state. That means that self-determination could be exercised internally in most cases. It wouldn't require secession, but through democratic means, people could make those in power accountable, such as through regular exercise of free and fair elections. As some of the remedies for violations of the right to self-determination in the practice of the African Commission, the African Court has not yet developed jurisprudence in that respect. Include examples I've included here. For example, in the year 2000, Uganda, Rwanda, and Burundi invaded Congo. Their troops were there, and the African Commission required that they withdraw troops from a state's territory. That's a form of domination by some African states, even in another neighboring states, and ordered payment of adequate reparations for victims of human rights abuses. That's just an example to show that domestic human rights institutions could make a contribution in the process of realizing human rights, if their decisions are respected or enforced in practice. There is an example in Cameroon where the Commission called on parties to engage in a constructive dialogue. This was an allegation of 1,000 Cameroonians being excluded from decision making. So it is possible for regional human rights institutions, commissions, courts, to play quite a progressive role in the process of making those excluded to be included, in the process of ensuring accountability, in the process of making sure that peoples are free from subjugation or domination, either internally or externally, whether by an imperial power from a neighboring state or from domestic elites. And before I can conclude, it is essential to note that one of the ways the African Charter also contributes to the protection of human rights in a progressive way is the sense that it was one of the first documents to protect civil and political rights, together with economic, social, and cultural rights at the time where there was a debate whether or not economic, social, and cultural rights could be enforced. The Commission stressed quite very strongly that those rights are enforced. In addition, the Charter protects group rights like self-determination, development, peace and security, satisfactory environment, because those rights are critical, not only to the protection of group rights, but also they provide a framework within which individual rights could be realized. It also takes into account the fact that human rights entail duties, so it imposes certain duties on individuals at a family level to participate in local, national, and international communities. Since then, the Charter has been supplemented by so many other protocols protecting, for example, rights of women, older persons, persons with disabilities, those are vulnerable groups who are normally excluded. So the protocols make the human rights framework more inclusive than it was in 1981. So finally, I should talk about the future African Court of Justice and Human and People's Rights. You may be aware that in 2014, the African Union adopted a protocol which amended another protocol. So it's known as a protocol on amendments to the protocol on the Statute of the African Court of Justice and Human Rights. It's just a protocol which creates a new court known as the African Court of Justice and Human and People's Rights. It's quite revolutionary in the sense that it's a 3-section court, a court with a general affairs section, which resolves interstate disputes, with a human rights section, protecting individual and group rights, and an international criminal law section, which prosecutes international crimes. The list of crimes is very long, longer than that prosecuted by the International Criminal Court. You know that the jurisdiction of the International Criminal Court is limited to 4 crimes: war crimes, genocide, crimes against humanity, and aggression. But you can see the list is very long, 14 crimes. And those are crimes, some of which are very particular in the African situation. So that's another step to ensure that serious violations of human rights in the future could give rise to individual or corporate criminal responsibility. Unfortunately, the elites excluded themselves from being brought before the court. You see, there is that famous Article 46A bis, which provides that no charges shall be commenced or continued before the court against any serving African Union head of state or government. And it goes on other senior state officials based on their functions during their tenure of office. So it means that you see an example here where a progressive document is being undermined by the very same individuals who adopted it. You want human rights to move to another level so that serious violations of human rights, giving rise to international crimes, can be prosecuted at a regional level. Those who exercise power and therefore most likely to violate rights include a provision that they can prolong themselves in office and be protected against individual criminal responsibility. The examples of heads of states who have been in power for over 3 decades. So if there is a potential to prosecute them, one would expect that without struggles, they would do everything they can to die in office. By way of conclusion, the essence of human rights and decolonization are not contradictory. They are the same. It's the struggle for freedom against injustice, oppression, and abuse of power in all its forms. These are struggles by marginalized and oppressed peoples against domination and exploitation, regardless of its source. There are recent examples of where, using peaceful means, it has been possible to have heads of states removed from power, beginning with Zimbabwe, Algeria, and more recently, Sudan. At one time, the head of state of Sudan stated that the International Criminal Court was below his shoes. At the time, the court issued a warrant of arrest for alleged war crimes and crimes against humanity and later genocide committed in a place known as Darfur in Sudan. He's now out of power following peaceful demonstrations in which women played a very critical part in that regard. So it's an example of struggles where people who have been excluded for quite some time could, through peaceful means, lead someone very powerful to be down. One hopes that there would be means of accountability in the future. So I would stop there. The rest could be discussed. Thank you for giving me.
Thank you. Thank you, Professor Segnonjo. I thank you very much. I don't want to intervene at this stage, but I have some questions, and I thank you for this thought-provoking intervention. Now I give the floor to Apollin Coagnet-Zoapé, who will talk about the puzzling African human rights system, who should do what. And I ask, please, to Apollin to remain within the 20 minutes.
Thank you very much, Professor. Thank you.
We allowed a sort of immunity to Professor Segnonjo, but
thank you very much, Professor.
With you, I will be strict.
Thank you for the University of Trento for inviting me. I want to thank all the organizers except Francesca, and I want to explain why. I was convinced that Francesca was my friend when we met in Luxembourg. I knew that we disagree on some points about your presentation in Luxembourg, but I was convinced that you was my friend. So when I received your invitation, I was very happy as young scholar to speak. And then I received the program, and I saw the name of the president of the International Court of Justice. And I see, this is a terrific moment. I also saw the name of Professor Segnonjo, who is one of the most known scholars on the African human rights system. So for a PhD student, I feel like in a trap. I say, Francesca was my friend. Why she did this? And my confusion went up when I started to work on the issue, on the puzzling African human rights system. Who should do what? And I read so many papers, so many books on the issues without two people agreeing on the same solution. I really feel in a trap. And the first question after all my reading was, are we really facing, I don't know if it's working?
It's my revenge. Just try.
Is it okay?
I have to push on.
Good. Okay, thank you. So the first question was, are we really facing a system? When we are speaking of the African mechanism of protection and promotion of human rights, there is a kind of systemic reading on the presentation of the mechanic of protection of human rights in Africa. But are we really facing a system? Like Jean Combako said, the word system is used by scholars like a sort of facility. When we see something, we don't have any other word to qualify. We just say, this is a system. Are we using the word system for the African mechanism because there is no better word? And when we are speaking of a puzzling system, why is it puzzling? Is it because we are doing a sort of comparison between what is in Africa and other systems? Maybe like the body who is in the eye of the person looking at it. Maybe the puzzling is in our mind. Is the African human rights system really a system? Let us start by the definition of what is a system. Professor Combako wrote a very known article in the francophone community, Le droit international, bric-à-brac au système. And he discussed the concept of system. And here is the definition of what is supposed to be a system. The first important thing is that is the idea of order. A system is the contrary of disorder. You have something which is not a random. You have a sort of order. And the second element, important element, is the link between each of the elements, so that you cannot analyze only one of the elements without losing the view of the entire. And Professor Olinga, in the basis of the Combako definition, proposed 4 elements on what is supposed to be a regional human rights system. The first element is a normative statement of the material rights to be guaranteed. Do we have in Africa a normative statement? Of course we have. You just listened to Professor Senyonjo. Yes, we have a normative statement. Second, an institutional architecture dedicated to the protection of the rights. Do we have that in Africa? Yes, we have the African Court, we have the African Commission. But the more problematic thing is the third element of Professor Olinga, a coherent articulation between the normative elements and the institutional elements. And fourth, the capacity of the institutional elements to protect in an effective and efficient way the rights. So when I try to apply this to the African system, I remember my course of physics when I was in lycée. You know, the Big Bang. This is what Google proposed me, like an image of Big Bang. At the beginning, and this is something essential when we are thinking about the African human rights system. When you read the works of Kebambai or other drafters of the African Human Rights Charter, there was no thinking of creating a system. That was not the idea. So, if you say that the system is puzzling, maybe it's because the system didn't know that it was a system. We are trying to say to the system, you are a system. But at the beginning, there was not a system. There was only an idea to protect human rights in a particular moment in Africa. So, there was no logic, no initial guideline, no upstream coherence on what we have now. What we call the system in Africa is the consequences of some specific problem in Africa and governments trying to put some specific solution in a specific moment. For me, this is some preliminary objection I want to make before trying to answer the question. The African human rights system was not a system at the beginning. So my contribution now is how now to build a concrete and coherent system. I will take the same démarche as the African Union in the African architecture of governance. There is 3 steps. The first step is the national, then the regional, and after that, the continental. So who should do what? The first important thing in my point of view is to move from formal articulation to concrete application of the central role of national institution. There is no system of human rights protection without a clear role, a preeminent role to the national institution. As the Botswana Appeal Court said in a decision in 1994, it is to the national judge to ensure the application and the respect of human rights. And in Africa, this is especially important because when you read most of the constitution of African countries, the charter is part of what the French call the bloc de constitutionnalité. In most of the constitution, the charter is part of the fundamental role of the country. Most of the African country constitution refer to the charter like one of the bases of the system. This means what? This means that in Africa, the first judge is the constitutional judge. The first judge of the African human rights system is the constitutional judge. And then the constitutional judge should do 2 things. The first is to ensure, in the idea of the hierarchy of norms, that laws in the country respect the fundamental norm, which is charter. Not the charter like an international instrument, but like a part of the value of the national system. The second thing is that the constitutional judge, in its role of regulation of public powers should ensure that human rights, as defined by the Charter, are respected. The second thing is the national judge. And here, they have did a lot of good work. I just read two important ones, Professor Villejoin and Professor Maurice Kamto. And when you look at Africa, there is a clear division between English-speaking countries and Francophone-speaking countries. English-speaking countries are more aware, take more the time to look at the African Charter, not in the Francophone countries. So something has to be done in all the countries to ensure that each national judge uses the Charter in his daily work. The other thing I want, yes, that's already the next PowerPoint. It's okay, yes. The other thing on which I want to insist is the judicial narcissism. This is something important, and this was the point of disagreement with Alexandra in Luxembourg. Because Alexandra was so happy with the decision of the High Court of Pretoria on the issue of Tribunal of the SADC, and since December we have a decision of the Supreme Court of South Africa. On the point of view of the protection of human rights, of course it is a very good decision, but I feel a little bit confused when a constitutional judge of a country thinks that he had the power to control what a regional organ is doing. I'm not sure that it's the role of judge to control what is happening in international organization, even in the perspective of human rights. Because the decision the Supreme Court of South Africa just take, imagine that the Zimbabwe court is in a total different point of view and say, no, I disagree. What will happen? So for me, the judge, the national judge, as the first in the application of the Charter, should avoid what I call the judicial narcissism. He should be aware of what is happening, and in particular in that case, because the African Commission on Human and People Rights said in that particular case that there is not a right, a continental right based on the Charter to access to regional jurisdiction. And the South African court took a radically different decision. And if you are speaking of a coherent system, this can be a problem on my point of view. Other thing concerning the national level is the question to access to justice. If you want the national judge to be the garant of human rights, you must be sure that all African citizens can access to a judge. And this is still a challenge in Africa. In many countries, the access to a judge is still a problem. So we have to work, and I will make some proposals when I will discuss the case, the role of African Commission. We need to ensure that each African citizen can have access to a judge. And for that, there is a good provision in the African Charter. It's the Article 25. There is an obligation for each country to ensure the education on magistrates, on judges, on lawyers, on human rights. I am a Cameroonian. I learned my first human rights course on Africa in a special course. I had my first master. I learned a lot about European courts. I learned a lot about human rights in general, but nothing about the African system. It's only when I start a second master in international public law that I had a special course on African system. I have some classmates who are now judges in my country, but they never study the African system. This is a problem. We should be sure that the provision of Article 25 is respected by all the countries. For me, this is something important. And then we move to the next level. The next level is the sub-regional level. And here there is a clear gap. There is a necessity to ensure the articulation between the regional and the continental level. And the idea is not new, even if most of the scholars, when speaking about the ECOWAS Court, are thinking that it's something new. When you read the work of the drafters on the very first meeting on the draft of the African Charter, the idea was already there. There was people thinking that due to the size of the Africa, the best thing is to have regional courts, not a continental court. So the idea is not new. This is a very old idea. Even at the beginning, when the charter was drafted, there was already, with people like Ibrahima Fall, thinking about a regional court. And there is a clear link between regional integration and human rights. Once more, all the treaties on regional organization in Africa are based in charter, in the African Charter. So the African Charter in Africa is first an international instrument, secondly, a national value due to the constitutionalization of the Charter, and third, a communitary obligation, because all the regional organizations refer to the Charter like a basis of the integration. So, the Charter can take advantage of that because of what we call the immédiateté normative of the Charter, based on the specific way the integration works. And this is something important, this is something interesting. And here, the proposition is, once more, to avoid that the application of the Charter depends on the place where you are in Africa. And the idea came after reaching a decision on the ECOWAS Court. It was the case CGP against Burkina Faso. In that case, the ECOWAS Court had two protocols. The first one was the African Charter on Democracy, Election and Governance. This is the continental instrument. And then the ECOWAS had a regional instrument, who was the ECOWAS Protocol on Democracy and Good Governance. And the judge did not try to conciliate the two. He decided that he had only to apply the regional instrument and pushing away the continental instrument. This can be a challenge for the system. This means that finally, if you are based in Mali or you are based in Algeria, your right depends on the place you are. And this is not good for the system. So once more, the regional judge, when applying the normative instruments of the regional level, need to have an eye on what is happening on the continental level. And this also happened in front of the ECOWAS Court about the rule of the exhaustion of local remedies. You know that the ECOWAS Court decided that this rule is not imperative. You don't have, when coming in front of the ECOWAS Court, to exercise the exhaustion of local remedies. On contrary, in the case law of the African Commission or in the African Court, this is an imperative rule. So finally, there is a difference if you are in Central Africa or in Western Africa. And this is a challenge for this when we are speaking of system. I can also say a word about the litispendence. The ECOWAS Court say that there is not litispendence between a pure judicial organ and a quasi-judicial organ. This means that you can cite in the same time the ECOWAS Court and the African Commission. It is true that in that case, it was a case between the ECOWAS Court and a UN organ. But on the principle, this is a problem, because the African Commission is not a judicial organ. And if you apply the ratio decidendi of the decision of the court in that case, this means that there is a real risk of litispendence between the African Commission on Human and People Rights and the ECOWAS Court. And then, as I said, The important thing in building a system, a coherent system, is the need of cross-fertilization. When you read African decision, there is so many European references in the case law. Sometimes when you read the African court decision, it seems that it's a European judge speaking. You have so many cases referring to Europe and nothing about Africa. And the same thing in the ECOWAS court. They are using a lot of references coming from Europe, sometimes from the anti-American system, and nothing about the other African system. But I think if we are thinking of a system, we need more cross-fertilization. That when the ECOWAS court is taking a decision, he should take the time to see how the African court, how the African Commission apply that specific article. And this is something lacking. We are using a lot of importation from Europe, from America, and doing like nothing exists in Africa. And for me, this is a real problem for if you are speaking of the system. Once more, it seems that for the same article, from the same section of the African Charter, the content of the rules can differ from one part of the continent to other. And this is a problem. So how to establish what Delmas Martil called the pluralisme ordonné? This asks for each judge first to build bridge between his own jurisdiction and other jurisdiction in the continent. But how? And here there is the question I was asking myself, and this is a question I am asking all of us. Do we need a primacy of interpretation of the continental jurisdiction to ensure the coherence of the system? There are concretely 3 proposals that have been done. The first one is something like the new protocol in Europe, the possibility for national judges to ask advisory opinion to the Continental Court, or what we call in French, renvoi préjudiciel, that a national or a regional judge being face of an article of the Charter to ask the constitutional judge, what is your understanding of this provision, and apply to the case. But this needs to establish a clear link and have a protocol like we have now in Europe. And what happens if a national judge refuses and says, no, I think that this article is enough clear for me to apply it without referring to the continental judge. And one of the proposals is something I took in the OADA system. The OADA system is the Organization for Harmonization of Law of Business in Africa. In the OADA system, when the Procureur General, because there is an obligation for national judge to refer to the continental judge when a disposition of the treaty is not clear. But the OADA treaty also said that if the court, the Cour commune de justice d'arbitrage based in Abidjan, is convinced that the way the treaty is applied in countries is problematic, without a referral, the court can decide by itself to say, I have to give my opinion in that specific issue. This means that in the case of the Africa, the continental judge could decide in a case that the way regional or national judges are applying a specific disposition is problematic, and then I will give a decision on a specific way. Another proposal which has been made by Professor Samuel Priso-Esawe of Grenoble is the Professor Senyojo, already present the next court with 3 chambers. Professor Priso-Esawe is proposing a 4th chamber, a chamber of conflict, based on what is happening in France, for example, Tribunal de Conflit. When the administrative judge and the judge of cassation don't agree, they have a sort of tribunal, the conflict tribunal, which takes a decision binding to all judges. So the proposal of Priso Isawe is that we have a judge in the next court who is a sort of conflict judge, and when there is a difference of interpretation, he can just give the good solution. And at the end, the last level is the continental level. What you see is what we call the Africa governance architecture. We have two things like this in Africa. We have the Africa governance architecture and the African peace and security architecture. So, in the first cycle, these are organs which have a direct mandate on human rights. And in the biggest, you have organs which have an indirect mandate. And when you read the document, the architecture, it seems that all the organs in Africa have a mandate in human rights. The human rights seems to be a sort of transversal competence to all the organs in Africa human rights system. So for me, one of the things to do is to end the bottleneck at the continental level. How? The first thing for me is to avoid entrusting technical tasks to political organs. When you read, for example, the African Charter on Cultural Renaissance, the African Charter, Article 37, say that the interpretation of the Charter should be done by the head of Conference of African Union. This is a problem. You cannot ask to a political organ to give interpretation of an article to be applied by judges. We should ensure that in the interpretation of all the normative instruments should be the competence of only technical organ. And in the other hand, we should avoid the technical organ doing politic or diplomatic tasks. I really feel uncomfortable on the actual practice of the court. The president of the court, the African Court of Human Rights, going to African countries to say, please make the declaration of Article 34.6 so that I can judge you. Maybe this is my francophone tradition. I see the judge having a sort of majesty. The judge don't have to go to people to say, please come, I want to judge you. For me, this is something incoherent. So we don't have to give diplomatic and political tasks to technical organs. We should ensure that, yes, all of you have a mandate on the field of human rights, but technical tasks only to technical organ, and political and diplomatic tasks only to politic and diplomatic organs. And then another idea I had was maybe a sort of rationalization between normal and emergency situation. When should the African Commission work with the Peace and Security Council of the African Union? When should the African Commission refer to the Conference of Head of State? Until now, it's not so clear. And you have the impression that everyone can do everything at every moment. So we need to have a clear rationalization. And the last thing on that specific issue is the question of the principle of what I call the principle of subsidiarity. We should think who should do what, and in the perspective of efficiency. Like in the model of the European Union, the continental level should be entrusted the task only if you are convinced that this is the best way to achieve this particular goal. And the same thing for each level. And then, the last thing about the technical bodies of the system. In Africa, we don't have enough means, but we have so many organs. So the first thing is the rationalization. And the first question is, do we really need a specific organ for the right of children if you already have the African Commission? Do we really need that? So maybe something have to be done there. The second thing is, I think the African Commission can be entrusted only promotional activities, nothing in the protection field. And we have enough things to do in the promotional fields. The promotion of existing instruments, the encouragement for the ratification is not the court to do that. Monitoring and implementation of the continental court decision or regional decision, the coordination and monitoring of national human rights institutions. There is so many things the African Commission can do without doing a protection work. And this is something we can do. The other thing is the African Union Commission on International Law. The African Union Commission on International Law mandate is clearly to propose to African countries specific rules on specific issues. And then I think, as it states in the statute, Article 4 and 9 of the African Commission on International Law, it should be a sort of laboratory of observation, maturation, and revision of norms. So that it's not the role of the African Commission to say, I think that we need a new convention, or it's not the head of states cannot adopt a new instrument before referring to the African Union Commission on International Law to ask, do we really need this? I think this is something essential. And third, the protection must be entrusted exclusively to the court. But this means at least some preliminary things to be done. The first one is that, and this is why until now, the Commission still have a protection mandate, is because the jurisdiction of the court is not compulsory for all the states. So if you want the court to have that mandate, we should be sure that if you are party to the charter, automatically the court have jurisdiction in human rights matters. The second thing is that we should remove the barrier of Article 34.6. For me, this is something not normal. We should remove that barrier to ensure that all African citizens can go in front of the African court. And this is also a question. Do we really need a court with so many competencies? We just listened to Professor Senyonjo. And as George Ugegu said, Africa, the Malabo Protocol of Africa, the Malabo Protocol is creating something really exceptional in international law. The next African Court of Justice, Human and People Rights, should have jurisdiction on administrative matters of the African Union, criminal jurisdiction, and human rights jurisdiction. And I attended a meeting when the ICTR was thinking of closing, and I asked the question for the then prosecutor, Hassan Jallo, who was one of the drafters of the African Charter. And he said, actually, for one procedure in front of the ICTR, we need around $1 million for one procedure. And I was asking myself, do Africa have enough money for that? For the special chambers for Hissène-Habré in Senegal, we need European Union money to ensure that to trial Hissène-Habré. Are we sure that we can make that? Maybe we should think on that. Maybe we should have a sort of step-by-step approach. And when we are ready, we can have broad jurisdiction. As a conclusion, I hope I am still in the time, Professor.
Yeah, you're almost in the time. 1 minute.
Thank you. As a word of conclusion, for me there is 3 things. When we are speaking about the African human rights system, if we want the African human rights system to stop, to be puzzling, we need 4 important words: interaction, articulation, synergy, and coherence. And this means what at the beginning, the first steps? Each organ needs to know that it is part of a system. When the national judge is taking a decision, he really needs to know that he is part of a system. The same for the regional judge, the same for the continental judge, the same for the technical organs, that we are part of the system. I am only a cog, one element of the system. And then I should be sure that what I am trying to do is really participating of the building of the system. And the second thing, and this is where I can permit myself to disagree with the conclusion of Professor Bagdiveras, who is speaking of a need of judicial activism in Africa. And, you know, one of the predecessors of George Yusuf, President Gilbert Guillaume, said something about the ICD. He said, George don't make politics, but George cannot work without having an eye on how its decision and its work is perceived by the beneficiary of its decision. And he used this very nice sentence in Africa, in French, that le juge doit savoir jusqu'où n'est pas allé trop loin. The judge should refrain itself sometime of going too far. And this is exactly what happened with the African Commission. You know that now, during the session in Mauritania, the Executive Council of the African Union asked the Commission to stay in its mandate. And now that all the report of the African Commission should pass through the Executive Council. This is the consequences of many decisions of the Commission, because the Commission, on my point of view, trying to please civil society organizations. And maybe sometime the judge should refrain itself, because we should have a clear demarcation between what is the progressive interpretation and what is jurisdiction. What you are just interpreting and why and when you are just creating new laws. And sometimes I think the Commission went too far. So when I was thinking about this trap of Alexandra, I have two images. The first, when looking at on the African system, it was the idea of Darwinism. I think that is what you had in mind when we were speaking of the porcelain system, is that for most of us, when we are looking on the African system, we are thinking of something evaluating, like the Darwinism, going for something better. But on my idea, and this is my conclusion, and I was happy because that was an occasion to learn more about Leonardo da Vinci. I am sure that you all know this is one of the most known paintings in the world. The Mona Lisa, I think, the Giocondo. Is it that in Italian? Yes. And the technique is what they call sfumato. The sfumato. The sfumato is a technique that the painter just use new layers progressively to make its paint. And when I look at the African human rights system, this is exactly my impression, is that finally the system is the result of some constraint. Finally, African governance adding new layers progressively for what I expect should be a chef d'oeuvre like the Giocondo. So thank you very much, my friend Alessandra, for helping me having this talk. Thank you.
Thank you, Apollin. Thank you also for, not trespassing too much the limits. We have, I would say, no more than 6-7 minutes. So if there is any question, please, on these first two presentations, I'll be glad to take them and to offer Marco Pertile, Professor Pertile. I don't know whether we have a mic. Yes, we have it.
In a situation of recent elections, coup d'etat, legitimate president, then reinstalled. So what is your view of this practice in Africa is very important. Huh? So what is your view of self-determination today in Africa? Total isolation from the outside so that the people is decide by ballot or by bullet, or intervention from abroad at times from scarcely legitimated countries, intervening in other countries to reinstall and make, so to say, legitimate electoral processes respected. So what is the best option? Intervention from outside or total isolation? This is your supplementation today now. Thank you very much.
Thank you. I think that these, maybe Matthias, Professor Hartwig is also asking something.
Thank you very much for very interesting conferences.
I think
it's not necessary.
you have to take them. No, because we are recording.
Okay.
Sorry, Matthias.
Thank you very much again. Yeah, the first question also deals with self-determination, not in the same sense, but in the sense of secession and of drawing new borders. Because we had the case of Biafra, for example, you know, lately Sudan, which found its own solution, but Cameroon, you know, we have problems there. What does secession and human rights mean in this context? It's would be very interesting. The first question. The second question, the question of the international criminal justice. The formula you found, I think it has a counterproductive effect. People want to stay in power instead of being tried.
You have to turn it on. However, I think that your voice was heard also from here.
And this is, of course, this is a sort of a paradox in the thing. The third thing is the question of piracy. You mentioned it. Here's my special interest. Will it be possible that, for example, the Chinese state brings a case before this court when pirates of Somalia seized a Chinese ship? We had the case with Kenya, you know. I think it was a scandal. I consider it to be a real scandal. And by the way, the German courts considered it to be a violation of human rights, what took place there. I'm very happy that Kenya stopped this way. But it would be interesting if now this African court could replace a substitute, so say, the litigations. We had decide on these cases. We had just two cases, I think, in the Western world, one in Germany, one in the United States. And otherwise, the pirates went free. There must be a solution to this. What you said was very interesting. The question of the comparative approach. Yes, there is this tradition also always to refer to Germany or to Europe. Within Europe, it's Germany. Within the world, it's Europe. I think it's not correct. The first reference must be done to your own system. And then you can broaden the perspective. This is very important. The last point I would like to make is the question of financing. You correctly mentioned it, that in many courts are financed from abroad. Even the Inter-American Court, 50% of the budget are paid by the Europeans. This puts into question the independence of these courts. Because then the Europeans will say, we will pay just for this with this trial, not for the other one. And this is a high risk. I think your countries, your continent shall be able to finance such a very important organ. Thank you very much.
Thank you. Thank you, Matthias. I think that, Professor Tognatti, I know that you were coming. So.
Thank you very much. I profited very much from both presentations, so thank you very much. I do have questions for both the speakers, but I'm afraid I don't have time. But the first question would be to Professor Segnonjo. You said twice that the theory is the one of the universal nature of human rights. Now, you said this is the theory, but you didn't tell us your own opinion about it. And you didn't tell us, I would say, the opinion of, shall we say, mainstream scholarship among African scholars. And one of the reasons why I'm asking this is that because I'm a reader of African constitutions. And in particular, since the 90s, there is an incredible common phenomenon, shared phenomenon by many countries of revitalizing indigenous law. And of course, indigenous law is always made subject to consistency with the Constitution, and in many cases, the Constitution does follow the universal inspiration. In other words, we Europeans feel very familiar reading those provisions. And yet, indigenous law is there, and there are interesting judicial decisions in making indigenous law compatible with the Constitution and, I suppose, with the African Charter. Now, would you think that talking about decolonization of human rights should entail also reference to indigenous law? Or is it something that you consider foreign to the process of decolonization? And if I may, just sort of footnote to the second presentation, very interesting, may I just say, don't forget that even in Europe, we don't have that great rationalization insofar as the Court of Justice, the case law of the Court of Justice is not subject to the case law of the European Court of Human Rights. So there is a gap, if you like, also in Europe in making it a unitary system. And of course, I don't know whether it is correct or not. But certainly I would hope that the African system takes off properly before you take into consideration the priority of rationalizing it. Thank you very much.
Thank you. Thank you very much, Professor Tognatti. I think that we have enough material for another workshop, just starting from these questions. So I refrain from making my questions. But please, you have 2.5 minutes each. So we have to finish by 11:30.
Thank you. Those are too many questions which are very challenging. Just a brief response, yeah? We can follow up the discussion. Question number 1 is about the best means. Should it be foreign intervention or should it be using domestic efforts? As a general rule, unconstitutional change of government is inconsistent with the constitutive act of the African Union. It is also a crime under the Malabo Protocol, which falls within the jurisdiction of the African Court of Justice and Human and People's Rights. One of the means of achieving unconstitutional change of government is by relying on foreign intervention. So foreign intervention which is not consistent with the Charter of the African Union and of course the UN Charter would not be justified. Of course, the concept of foreign intervention is also broad. Intervention in what sense? Is it military? Is it in terms of strategies? Is it in terms of financial support in accordance with the domestic constitutional framework or with the international framework? They are all various means. In a situation where foreign intervention can be justified in accordance with the principles of international law, there would be no problem with that. I can just give an example. For example, intervention in Libya, which led to the fall and the subsequent death of Colonel Muammar Gaddafi, the Libyan leader at the time. There was foreign intervention, but it followed legal procedures, through UN Security Council, which permitted using all means necessary. So it could be a combination of all means, provided they are consistent with international law. The second question about new borders, secession. The Organization of African Unity, as a matter of principle, stressed the need to retain colonial borders. There are a number of reasons for that, although they were arbitrary, but in the interest of international peace and security, the general principle is to follow and maintain colonial borders. So self-determination could be exercised, internal self-determination, without necessarily states having to secede. Of course, there are examples like South Sudan, which followed domestic law and international law through a referendum, and some exceptions could be justified where there is sufficient practice to justify that. The question of immunity is a valid observation. It is unfortunate that you want to create and strengthen accountability, but at the same time exclude some individuals from being accountable. If you are not going to commit an international or transnational crime, why should you fear appearing before court? So creating a court for non-state actors is a form of continuous colonization of human rights, using human rights against some others and then protecting groups, individuals violating human rights from being accountable. My colleague here suggested the removal of 34.6 in the protocol, creating the African Court. This is another provision which would require future removal. But as you may know, since 2014, no single African state has ratified the protocol. So almost 5 years later, the protocol has not been ratified. So there is some politics even involved in adopting these instruments, because at the time it was about President al-Bashir, Kenyatta, and his deputy at the time appearing before the International Criminal Court, which was being seen as a new neo-colonial judicial institution. So you needed an African alternative to the International Criminal Court so that crimes allegedly committed in Africa are prosecuted in Africa. But it's a reverse. By excluding them from accountability, you leave the door open for the International Criminal Court, which in a way could also be something progressive. The question of piracy, whether China could have access to the court, access is very limited to that court. Even Africans themselves, there are limitations on access. So China cannot be a state party to the protocol, and therefore it cannot access the court in that context. Financing the court is a valid criticism. It's too expensive in the poor continent in the current circumstances. But there is a right to international cooperation, assistance, which could be used. I see no problem with that. If there are genuine cases before the court, it could probably be cheaper to prosecute them in Africa than prosecuting them before the International Criminal Court. It's not even cheaper here. The court is the one of last resort. The final question about whether human rights, I said human rights are universal in theory, and what my view is about this. Yes, the theory is very well known. There is consensus within the United Nations that human rights are universal, and the states have an obligation to protect all human rights, regardless of cultural differences. The reality, however, is that human rights can be seen as being relatively universal. So there is some relativity in universality. We can take an example. For example, the right to marry and find a family. Polygamy is practiced in Africa and is protected by a specific provision in the Protocol on the Rights of Women in Africa. So it encourages monogamy, but at the same time recognizes that states can promote human rights within polygamous marriages. The only polygamy permitted is the one where a man can have multiple wives and not the other way around. From the UN perspective, that constitutes unacceptable discrimination against women. But the African reality is that, okay, we can all protect marriage, but it could mean different things in a different context. So the right to marry being relatively applied differently in different contexts. And finally, should indigenous law be also subject to decolonization? Certainly. Or laws where there is evidence of abusive power, whether it's at a local level, whether it's at a national level, whether it's within indigenous groups or minorities, should be subject to continuous improvement in the sense that laws should promote human dignity, they should promote justice. So even indigenous laws should be subject of decolonization process. It doesn't matter whether abuse is at an indigenous level, at a local, at a national, regional, universal level. We need a better world to live in. Briefly, those are my responses. I'm sorry if I have not addressed some aspects, but we can
Thank
continue.
you very much.
Thank
you. Apolline, do you want to intervene?
Yeah, just one question, the question about the self-determination. I totally agree with what the Professor Senyojo said. When you read the Charter, the Article 19 and 20 of the Charter was a use of human rights for a political perspective. When the Article 19 and 20 of the Charter was wrote about the self-determination, it was against Western countries to say, we need to use human rights to decolonize some country in Africa, Namibia, and others. And today the debate is Article 20 allow a right of self-determination for people inside the countries in the case of violation of democracy and everything. And when you read the decision, Professor present, the decision against DRC and the decision, the Kevin Boone against Cameroon, the Commission is really trying to do a sort of equilibrium, a very delicate equilibrium, because the Commission says you need to know that the principle of the non-intervention, the principle of protection of the frontiers of country is imperative. And just a kind of evocation of the theory of situational remedies to say the countries, the right of self-determination is internal self-determination. That countries should ensure that all citizens have the right to participate in public affairs. And then I propose myself, as Professor said, to help for that. But the Commission refused to draw conclusion, because even in the case letters, the Commission refused to draw conclusion for the Kevin Boone position to say clearly that, yes, in case of violation of human rights, there is a right of self-determination, there is a right to intervene, like stipulated in Article 4 of the African Union Constitutive Act. So yes, until now, but for most of the scholars, and I think there is, I share totally the view of the Special Assistant of the President of the Court, Mamadou Ebie, on the issue, on the commentaries did on Article 20, that when you read the work of the drafters, the idea was not to allow a right to self-determination. So that the right to intervene, on my point of view, should be looked in the right of intervention of the organization, Article 4 of the Constitutive Act, rather than in the African Charter, because that was not the perspective of the African Charter. Thank you.
Thank you. Thank you, Apolline. We are running out of time, so I propose we have a break now until 11:45. So a very short break, and we will resume our works in 10 minutes. So if you want, I think there is coffee or something, Giustino Dorazio Hall. Okay, but please be on time here later on. Thank you. Okay, so I'm sorry. I said something that was not true, so I apologize. I thought there was a coffee break. It was not an organized coffee break. It has been a free coffee break, so to say. However, this allows us to start again on time, and I will now give immediately the floor to Professor Konstantinos Magliveras from the University of the Aegean in Athens. Professor Magliveras is an expert, is a professor of international law and law of international organizations and criminal law, but he's also an expert in international and regional protection of human rights and transnational migration and international NGO laws. He has a special interest in Africa and Arab Islamic legal affairs and institutions. Among his publications is the author of the book The African Union that was published last year with Professor Naldi. I give him immediately the floor. Professor Magliveras, will speak about the role of Africa's supranational courts, judicial activism or resistance, question mark. So I also ask him, of course, to remain in the time limit. The floor is yours, Professor Magliveras.
Thank you very much. Thank you, the organizers, for the kind invitation and for the most kind hospitality. The purpose of this presentation is to offer a detailed overview of the current status of continental courts of justice in Africa, describe problems, challenges that they face, and principally the fact that the Court of Justice of the African Union is not yet functioning. Reference will also be made to the various processes towards economic integration presently pursued in Africa, and will...
Otherwise, you can... Okay.
And finally, I will offer some comments and suggestions. As probably you all know, the Organization of African Unity did not include the Court of Justice. The first continental court was the Court of Justice of the African Economic Community in the early 1990s. However, this project never flourished. Milestones said were never materialized. And for all intents and purposes, the African Union has abandoned this project. The first continental court of justice to actually become operated was the African Court on Human and People Rights, established in 1998. It completed the institutional mechanism of the African human rights system. While it is widely regarded that the African Human Rights Court forms part of the AU's institutional structure and architecture, actually it's not a proper AU organ. The same applies to the African Human Rights Commission, which was the original organ established under the African Charter on Human and People's Rights, to which I will refer to as the Banjul Charter. The next African instrument to create the Transnational Court of Justice was the African Union Constitutive Act. In particular, Article 18 envisages that the organization shall be endowed with its own judicial organ to be called the African Court of Justice. However, it left details to be agreed on the basis of a future protocol, which was finally concluded in July of 2003. Its jurisdiction is extensive, and this could be explained by the fact that to a certain extent it is modeled after the Court of Justice of the European Union. The protocol on the African Court of Justice came into force in February 2009. While one would have expected that it would have already been up and running, in the mysterious ways that the African Union often functions, the African Court of Justice has never been operationalized. The only rational explanation for this rather irrational state of affairs is that in 2008, the AU Assembly decided to merge it with the Human Rights Court to create the African Court of Justice and Human Rights, to which reference has already been made by the previous two speakers. In May 2012, a draft protocol on amendments to the protocol on the African Court of Justice and Human Rights Statute was submitted to the AU Assembly for consideration. Main goal was to allow this court to acquire jurisdiction over the alleged commission of international and transnational crimes by individuals as well as by legal persons, and we should emphasize legal persons. What would appear to have urged the Assembly to go ahead with conferring international criminal jurisdiction to the African Court of Justice and Human Rights was the opposition of a group of member states to the International Criminal Court, a reference to which we heard just before the break, including countries which participate in the ICC and have recognized its competence in the field of transnational criminal justice. In the opinion of these states, the way the ICC behaves towards African heads of state and high-ranking officials is offending and unacceptable. Indeed, the states have maintained that the ICC has been targeting only African dignitaries while completely ignoring and neglecting crimes committed elsewhere in the world. In June 2014, the Assembly adopted the Protocol of Amendments creating a revised African Court of Justice and Human Rights, the well-known Malabo Protocol. To the two existing sections, namely the General Section and the Section on Human and People's Rights, a third section was added, the section on International Criminal Law. There is no doubt that the African Union should be congratulated for so boldly devising the revised African Court of Justice and Human Rights, a judicial organ with unparalleled powers and functions among international organizations. But unfortunately, it has to be included in the long list of African Union projects which have seemingly been abandoned. The Malabo Protocol has not been ratified by a single member state 5 years later and has been signed by only 11 countries. Note that among the signatory parties is none of the what I would consider heavyweight countries in Africa like the Republic of South Africa, Nigeria, Egypt, etc. In the years to come, as the mandate of the African Union augments, the importance of having a fully functionable judicial organ will no doubt become even more important. Particular attention should be placed on the project of creating an African continental free trade area, which member states decided to launch in the course of 2018. While the African Continental Free Trade Area was launched as a continental-wide economic integration project, there have been other similar projects implemented by several regional economic communities, the so-called REGs, acting either on their own or in collaboration with each other. The effective parallel operation of all these different integration projects will no doubt necessitate fine-tuning, and the various questions and issues that might emerge should be dealt with through a judicial organ. Regarding RECs, as Dr. Pascale will no doubt explain, several of them have been endowed with judicial organs functioning as transnational courts of justice for their respective member states. My brief reference to these judicial organs is restricted to the role in dealing with disputes pertaining to the respective RECs free trade area. These organs include the Court of Justice of the Common Market of Eastern and Southern Africa, COMESA, and the East African Court of Justice of the Eastern African Community. Regarding the Tribunal of SADC, the Southern African Development Community, unfortunately, its operation is still suspended. Presently, the process of economic integration in Africa is pursued at three different levels. The first is the sub-regional level. It corresponds to the action taken by individual RECs, like the ones mentioned just before. The second is the continental level, which should materialize in the form of the African Continental Free Trade Area. The third is the regional level, which thus far has taken the form of the tripartite free trade area between COMESA, the Eastern African Community, and SADC. It comprises a total of 27 states, but until now it has not come into operation. As the situation now stands, and there is nothing to suggest that it will change in the near future, the only African Transnational Court of Justice that could play a role in dealing with continental matters, and especially with economic integration matters, is the African Human Rights Court. But of course there are many limitations in what it can actually do, and this fact should not be underestimated. Thus, it is not a court of general jurisdiction with limitless competence, but forms part of the African system for the protection and promotion of human rights. The question that arises, and which I would like shortly to explore, is to which extent it might be possible to use the African Human Rights Court as a legal avenue to resolve matters affecting the African continent, especially in the field of economic integration, where, as we have just seen, African states and the African Union itself have been most active as of late. This presentation will support the view that this might be possible, and this view will be based on three considerations. The first is that the Banjul Charter protects a number of human rights which could find application in a process of economic integration, and which, if breached, the African Human Rights Court could, subject of course to all other procedural requirements being met, be sized to rule on the existence of a violation. The alleged violation could also take the form of domestic legislation which is incompatible with the provisions of the Banjul Charter. The second consideration is essentially based on an expansive interpretation of Articles 3 and 7 of the Protocol establishing the African Court of Justice, which concern its jurisdiction. Finally, the third consideration has to do with the competence of the African Human Rights Court to deliver advisory opinions. Time does not permit me to deal with the first two considerations, but I would like to explore the third consideration in particular. It centers upon the competence of the Human Rights Court to render advisory opinions pursuant to Article 4, Paragraph 1 of the 1998 Protocol establishing the African Human Rights Court. The fact that Article 4, Paragraph 1 says that advisory opinions may also be requested by any, and I quote, African organization recognized by the African Union, unquote, could become a very important tool to compensate for the lack of a functionable continental court of justice. The African Court of Justice, the African Human Rights Court of Justice, in its advisory opinion in the case of Socioeconomic Rights and Accountability Project, SERAP, which was given in 2017, held that the term organization, as in African organization, covers both non-governmental and intergovernmental organizations. No doubt the term intergovernmental organizations cover the various RECs and possibly other international institutions which are headquartered in Africa and whose mandate focuses on Africa. I have particularly in mind the African Development Bank. As regards the proper interpretation of the second requirement, namely that the organization in question must also be recognized by the African Union, in the same case, in SERAP, the applicant argued that its observer status before the Human Rights Commission, this is the African Human Rights Commission, should be adequate to be considered as, quote, recognized by the African Union, unquote. And you might have thought that this is a very reasonable and rational argument. Not so for the African Human Rights Court, which flatly rejected this argument. It held, and I quote, "It is clear that the authors of the protocol establishing the African Human Rights Court intended that requests for advisory opinions from NGOs be limited to those with observer status before or with a memorandum of understanding with the African Union." Now, my interpretation of this case is that the African Human Rights Court chose to give a very broad interpretation to the term organization, and expressly included NGOs, even though, as we all know, there is no internationally accepted definition of what a non-governmental organization is. But then it went on to restrict considerably the ambit of permitted NGOs by demanding that they have been conferred observer status by the African Union or have concluded a memorandum of understanding with it. My understanding is that presently no NGO has been conferred observer status by the African Union pursuant to the criteria that the African Union Executive Council adopted in 2005. And what exactly a memorandum of understanding is quite unclear, and the African Court of Human Rights did not elaborate. The situation concerning Africa's supranational courts is problematic, to say the least. Despite the many initiatives taken over the years, the state of affairs is that still there is no continental-wide court which is recognized and accepted by all countries. Even today, the African Human Rights Court is not recognized by Morocco, the 55th AU member state, because Morocco apparently has still not deposited her instrument of ratification of the Banjul Charter and the 1998 protocol establishing the African Human Rights Court. In my opinion, the situation is even more complicated because the African Union has a specific institutional architecture which envisages a judicial organ, and this judicial organ must take the form of a court of justice. It's not just a dispute settlement mechanism. It must be a court of justice. The operation of this organ is compulsory. It is not optional. And indeed, member states have no discretion at all in this matter. In my opinion, it is deplorable that on account of the behavior shown so far by the African Union membership, the continent has effectively been deprived of the judicial organ envisaged in the African Union Constitutive Act. As has been explained, the protocol establishing the African Court of Justice came into force 10 years ago, in 2009. Irrespective of the subsequent project to create the African Court of Justice and Human Rights, and then to add the International Criminal Law section to the African Court of Justice and Human Rights, legally speaking, there are no obstacles for the immediate operationalization of the African Court of Justice, the conclusion of the rules of procedure, indeed a task which the African Union Commission on International Law can undertake, and the Assembly electing its first bench. Whether or not the African Court of Justice should be merged with the African Court of Human Rights, and whether the merged court should have a separate section on international criminal law, are not questions which have to be addressed at present. In my humble opinion, these should be considered luxuries, especially when there is still no continental court in operation. And I think that African leaders have to realize that transnational courts are instruments for development and advancement. Moreover, according to some commentators, an African Union law as a separate legal system has been emerging. And the addition of new areas of activities to the African Union I've made earlier reference to the Continental Free Trade Area, should consolidate this AU legal order, which by definition will interact with the domestic legal system of African countries. But this cannot be carried on without a functionable Continental Court of Justice. The experience gained from the Court of Justice of the European Union is a constant reminder of the importance of having in place a truly independent and impartial court. But also the decisions given by the judicial organs of REX, of which we will hear in the next presentation, are also evidence of the necessity of having a court of justice in Africa's institutional architecture. It will be submitted that this state of affairs imposes a very heavy burden upon the Human Rights Court, since it currently is, and for the foreseeable future will be, the only transnational court in the continent. What the African Human Rights Court may do is laid down in the 2008 protocol which established it. But what this court could do, in other words, how proactively it may operate, is up to its bench. Of course, it cannot and should not substitute the judicial organ of the African Union, but it could, on its own initiative, relax the criteria for accepting requests for advisory opinions filed by NGOs which already have been granted observer status by the African Human Rights Commission. And even if it does not follow this route, it could continue rejecting the request for advisory opinions, but before doing so, it could at least discuss or offer its opinion on their subject matter. To conclude, what Africa is presently and urgently in need is, in my opinion, judicial activism by the African Human Rights Court, and of course the immediate functioning of the African Court of Justice. Thank you.
Thank you, Professor Magliveras. Now I'll give the floor to Giuseppe Pascale, who is Assistant Professor of International Law at the University of Trieste, where he works on public international law issues, international and regional protection of human rights, and international migration law. He has written extensively on human rights protection in Africa. In 2017, he published a book on this issue, on this topic. So, Giuseppe, the floor is yours, and I ask you please to remain in the, maybe if you can even shorten to 15 minutes, I'll be grateful, because we have not only the conclusion by President Yusuf, but also an intervention from Ambassador Sani, from in this moment in Nigeria, but usually is placed in Arusha in Tanzania. So the floor is yours, Giuseppe.
Okay, so thank you very much to the University of Trento for inviting me, and special thanks to my friend Francesca for this, for inviting me in this round table. Well, I had prepared a brief introduction, but you will not listen to my introduction because I will directly speak about the main topic. So, as other speakers have already said, sub-regional tribunals in Africa were created in the context of REX, the African sub-regional economic communities. They are put in the context of the African economic community, whose aim is to create an economic, commercial, and monetary union very similar to the European Union. And both in the instituting treaty of the African Economic Community and in many instituting treaties of the sub-regional communities, there are provisions concerning the creation of tribunals, even if in some cases these sub-regional tribunals are created by special protocol. But in an event, all the sub-regional communities that are more or less 14 today have sub-regional tribunals. Of course, at the beginning, these tribunals had competence only in the field of economic and commercial integration. But then, step by step, many of them, because of a matter of judicial activism, autonomously extended their competence to the field of human rights. It happened mainly because of two reasons. First of all, because references to human rights are present in their instituting protocols. References in general to human rights, but even in particular to the African Charter or to the Human Rights United Nations instruments. Then, second point, individuals can bring claims before such sub-regional tribunals, and as the model of the Court of Justice of the European Union tells us, it was quite natural for those sub-regional tribunals to extend autonomously their competence to the field of human rights. But the African states reacted, and I selected three main examples concerning the reaction of African states to this judicial activism in the field of human rights by sub-regional tribunals. The first model is a sort of paradigm because it is the most common, and it is that of the Court of Justice of the Eastern African Community. This Court of Justice still today exercises a competence in the field of human rights, even if provision lacks, even if member states have never attributed a specific competence in this field to this Court of Justice. In the past, negotiations began in order to adopt a specific protocol, but then there was the so-called Kenyan impasse, because the Court of Justice passed two judgments against Kenya that was qualified as responsible for many human rights violations, and Kenya stopped these negotiations. Now, roundtables are going on, but a protocol has never been adopted. In the seminal Katabazi case, then the Court of Justice underlined that yes, there is no specific provision concerning its competence in the field of human rights, but it must have also competence in the field of human rights when it is linked with economic and commercial integration in the Eastern African Community. So, the model of the Court of Justice of the European Union. Then there are two other different examples that, in my opinion, are the most important. The first one is that of the Tribunal of the Southern African Development Community, that developed a strong competence in the field of human rights until 2010. This tribunal passed several judgments against Zimbabwe, above all because of the Land Acquisition Amendment Act that the Zimbabwean parliament had passed in order to dispossess some white farmers of European origins of their lands. And the tribunal, the SADC tribunal, found that Zimbabwe was responsible of many human rights violations because of this domestic act. President Mugabe did not appreciate this judicial activism of the tribunal in the field of human rights, and then he, thanks to some strong diplomatic efforts, he was able to persuade all member states of the SADC to stop this judicial activity of the tribunal. And as a matter of fact, when the mandate of some judges terminated, the new judges were not elected, so the tribunal had not a quorum to work. Then a new protocol was adopted in 2014, but this new protocol just admit interstate disputes, so individuals cannot bring any claim anymore, and it means that it is quite sure that this tribunal, this new SADC tribunal, will not deal with human rights disputes anymore. As two scholars have written, one of them is here sitting close to me, this tribunal, member states have emasculated this tribunal. It means that they eradicated completely its human rights competence. From another point of view, there is a totally different example, that is that of the ECOWAS Court of Justice, that, as the other sub-regional tribunals, began dealing with human rights disputes at the end of the 90s, but then in 2005, member states adopted a supplementary protocol. And now Article 10, Article 9, Paragraph 4 and Article 10, Paragraph D of this protocol expressly attribute a human rights competence to this ECOWAS Court of Justice. I think that ECOWAS member states are human rights supporters not because they are simply human rights friendly, but because of political and economic reasons. It is a matter of fact that some international investors, like China or India, have chosen other African regions to invest. So, ECOWAS member states still need the economic support of the European Union, the Scandinavian states, above all, and then also United Nations, many NGOs, so international actors that usually care about human rights. So in my opinion, this explains why ECOWAS member states are still supporting the judicial activism of the ECOWAS Court of Justice in the field of human rights. In this context, the main problem, according to many scholars, seems to be that of overlapping jurisdiction between the sub-regional tribunals and the continental organs, that is to say the African Commission, but mainly the African Court. So, in the last 10 years, many scholars have searched for solution in order to regulate the relationship between the African Court and sub-regional tribunals. They say that many problems could arise if a solution is not found. First of all, the problem of forum shopping, and I think that here everyone knows what forum shopping is. Then there can be problem concerning the interpretation of the same international norm before different international tribunals. Well, in general, they say that the coherence of international law could be threatened. The point is that they believe that the general phenomenon of the proliferation of international tribunals that is at the very background of this regional situation, they believe that this phenomenon is a bad phenomenon, and this is why they are always searching for solutions. As I will say at the end of my speech, in my opinion, it is not so a bad phenomenon. But be that as it may, first of all, I would like to remember the idea of Professor Sceni, who speaks about international committee, and he believes that this concept of international committee could be applied even in the relationship between sub-regional tribunals and the African Court. Because international committee, according to Sceni, is included in a customary norm, and because all international tribunals operate in a context of intrasystemic integration or something like that. Well, in my opinion, this idea has not concrete legal basis, concrete legal parameters, but what is more, it would depend completely on the discretion of international judges. Then another scholar, that is Professor Mubiala, suggests to regulate the relationship between sub-regional tribunals and the African Court thanks to the advisory mandate, the advisory competence of the African Court. Because Professor Maglivera said already, has already said that the African Court has a competence to deliver advisory opinion because of Article 4 of the African Court Protocol. But of the African Court Protocol, and Professor Mubiala suggests to use Article 4 as a means to implement in the African system a sort of reference for preliminary rulings as the one existing in the European Union legal order. But, in my opinion, we should remember, first of all, that Article 4 does not speak about a system for preliminary rulings, but just about advisory opinions. Then it would be very difficult, in my opinion, to transfer a typical European legal model in the troubled African environment. And then I must underline that according to Article 4 of the African Court Protocol, intergovernmental organization, so the sub-regional organization, should ask the African Court for an advisory opinion. So they should some way agree with, there should be a sort of contact between sub-regional tribunals and sub-regional communities. And in order to adopt a decision to ask the African Court for an advisory opinion, in many cases a consensus is needed. And in my opinion, it is very difficult to find consensus among states belonging to sub-regional tribunals. Well, I say that because in general, to adopt decisions, they have to vote with the method of consensus. Then there are a lot of other de jure condendo solutions that have been suggested, for instance, by the former president of the International Court of Justice, Schwalbe, then by Professor Bennouna. They speak about the creation of a subsidiary organ to the General Assembly of the United Nations entrusted with coordinating the relationship among international tribunals. They also speak about the organization of periodical meetings or the codification of an obligation of reciprocal knowledge of each of their case law among international tribunals. The most important idea, the most interesting idea, in my opinion, is that of late Antonio Cassese, who well understood that there's no hierarchy in the international judicial landscape, and he suggested to create a hierarchy in this landscape with the International Court of Justice at the top. So he said that any international tribunal, so even African sub-regional tribunals, or the African Court, should ask to the International Court of Justice for an advisory opinion in cases of overlapping jurisdictions. But in my opinion, even if it is a very interesting opinion, it is very difficult to realize because it entails a modification of the statute of the International Court of Justice and of the Charter of the United Nations. Well, to conclude, as I said at the in the middle of my speech, those scholars who search for solutions in the relationship between sub-regional tribunals and the African Court consider the proliferation of international tribunals as a bad phenomenon. in my opinion, that's not true. First of all, forum shopping is not something bad, it's not something good, but I think it's something normal in international.
This is not me, but this is just Ambassador San, who is calling from Nigeria, but please complete your sentence.
It was a sort of
thank you very much.
So I was saying that it's not bad, it's not good, but it's something normal, because as everyone knows, justice in international law is based on parties' consent. So it is clear that parties can choose the judge that can settle their dispute. Then, furthermore, I can say that, in my opinion, the proliferation of international tribunals can be seen even as something positive. Because when two international tribunals deal with the same topic, they can can compare different interpretations of the same international norm, and it means improving the vitality of international law. And then let me say that there are few cases in which overlapping among different international tribunals dealing with the same disputes has happened. I can remember the Max Planck case or even the Tadic case, but nothing more. But, well, in any case, different interpretations of the same international norm helps the vitality of international law. And this positive interpretation of the proliferation of international tribunals helps, above all, in the field of international human rights law. This is an idea developed by Conforti, but even by other Italian scholars. And in my opinion, the relationship between the ECOWAS Court of Justice and the African Court is a concrete example of this idea, of the effectiveness of this idea. Because, by way of illustration only, and then I come to an end, had not the ECOWAS Court of Justice existed and spontaneously extended its competence in the field of human rights, the development of international human rights law, at least in Western Africa, would have been prevented, because the African Court has to abide by some provisions that are the outcome of negotiations among many African states, all African states. These rules are very strict. It's enough to remember that just 8 states today admit that individuals bring claims before the African Court, while in the ECOWAS context, rules are less strict. For instance, there's no the rule of exhaustion of local remedies and so on. So it was possible for those states who are human rights supporters, human rights friendly, to create a more developed human rights system, even if this system is limited to a region of Africa. And it happened without any effective need of coordination between the African Court and the ECOWAS Court of Justice. What is more, the ECOWAS Court of Justice in some case could be a good example for the African Court, and the ECOWAS region could be a good example for all the continent with regard to protection of human rights. So, to conclude, in my opinion, the necessity to find a coordination between sub-regional tribunals and the African Court is overestimated. And thank you.
Thank you very much, Giuseppe. Thank you for this clear explanation of an important argument, and thank you also for recalling us some friends who are not among us anymore, such as Professor Cassese and Professor Conforti. Now I I said at the very beginning that we, as the University of Trento, have a project, a very important project on the education of the Somali judiciary, which is going on. Although we have had some difficulties, we still have some difficulties. We hope that things will go better in the near future. But since our partner of this project is the African Institute of International Law, and namely Ambassador Mohamed Sani, who is director of the African Institute, I would like to give him the floor, asking him to be very, to make his presentation in a very short manner, because we have some problems of time. As you can imagine, since the President has to leave by 1 o'clock.
Ambassador Mohamed Sani, who is director of the African.
A certain return. Good morning, Ambassador Sani. Giuseppe Nessi. Do you hear me? So we, by way of introduction, good morning, Ambassador Sani. Do you hear me? I don't.
Yes, I can.
Oh,
yes.
Good morning. Yes, I was introducing you as the rector of the African Institute of International Law and our, I would say, co-author of the project concerning the training of the Somali judiciary, promoted by the University of Trento. We are here, as you know, speaking about the role of Africa's supranational courts in the protection of fundamental rights, contributions and challenges. And before we give the floor to President Yusuf, I would I'll ask you, please, to explain briefly, if possible, because we don't have so much time, the contribution of the African Institute of International Law to this issue that has been discussed today. So, if you can intervene, please, I give you the floor.
Thank you very much. Good afternoon, Professor Nessi. Good afternoon, Yusuf. Good afternoon. First of all, we are very grateful for being given this opportunity to intervene, and also we are sorry for my inability to be there personally. I wrote something very small, and it is about African Institute International Law contribution to supranational human rights litigation in Africa. The African Institute of International Law was established on the initiative of Judge Abdulkawi Yusuf, President of the ICJ, under the auspices of the African Foundation of International Law and in cooperation with the government of the United Republic of Tanzania. Its establishment was endorsed by the Assembly of Heads of State and Government of the African Union, and the AU decision underscored the strategic importance of such an institute dedicated to offering higher learning and research in international law and the law of African Union needed for the development of Africa. It also recognized the importance of the role it used to play in building the capacity of African faculties of law and African lawyers in dealing with various aspects of international law and African Union law. The United Nations General Assembly welcomed the creation of the Institute and encouraged the UN Secretariat to cooperate with it through the codification division of its Office of Legal Affairs, as adopted in successive UN resolutions on the program of assistance on the teaching and dissemination of international law. The establishment of the Institute at close proximity with certain number of the international judicial bodies in Arusha is intended to contribute to the work and support those and other Pan-African institutions on the continent with research and training activities in the field of international law and African Union law. The support of an academic and research institute is crucial to the development of the progressive jurisprudence of those bodies. its establishment was premised on the fact that it will be able to play the role of creating a highly skilled judiciary and legal expertise as a matter of fostering human rights in the administration of justice, considering the ever-growing impact that international human rights law has had on domestic legal system throughout the world, and thereby also on the daily work of domestic judges, prosecutors, and lawyers. The objective of the Institute pursues in this regard is therefore to enhance the knowledge and skills needed in the implementation of international human rights law to judges, prosecutors, lawyers, legal professionals without whom there can be no truly efficient protection of the rights of the individual at the domestic level. To this end, the Institute has embarked on a journey to implement training programs, seminars, and judicial dialogues, and the work we have done so far convinces us that the benefits of capacity development can help to strengthen the work of those international judicial bodies, particularly at enhancing their independence. Since its inauguration on 16 February 2015, the Institute has placed human rights at the center of its activities. Its training programs, covering a wide range of areas, have so far attracted more than 400 participants from
another time and then we go ahead.
I got disconnected.
Yeah, unfortunately.
Hello?
Yes, but
are you hearing me?
Hello?
Hello?
Yes. Please continue.
Hello?
I will ask you please to...
Yeah, sorry, I got disconnected.
Yeah, we got it. But if you can please continue, I think that we don't have so much time, so if you can complete your speech in 5 minutes, 3 minutes, 5 minutes, I will be grateful.
Okay, I will conclude quickly. We have done some training programs for including more than 400 participants, and it's all intended for young African people, such that we can ensure future human rights advocates and protectors. And this important program that is done by the African Institute of International Law is open to any other organization that is willing to come and assist us in this capacity building of legal professionals in most of the areas of international law. We are confident to state that the African Institute of International Law has come on stream to take the lead in building the capacity of African professionals, a great number of whom are involved in human rights litigation in Africa. The African Institute of International Law is now settled and recognized with strategic and unique role as a pan-African institution. We are working tirelessly to enhance its sustainability and success of its educational and training activities, ensuring a smooth running of its day-to-day management pertaining to coordinating its training, research, and capacity building at its headquarters in Arusha, Tanzania. International human rights litigation in Africa being one of its core activities. Any organization, institution, or individual interested in partnering with us in this regard is most welcome. Thank you very much for listening. Although I got caught up, I was talking, didn't realize it was. Thank you very much for this opportunity.
Thank you, Ambassador. No, thank you. We didn't lose a single phrase. So we recorded everything, and I really thank you very much for your intervention. I know that it has been quite difficult. Now I give the floor to President Yusuf. President Yusuf has been a judge of the International Court of Justice, the main judicial organ of the United Nations since 2009, and since the 6th of February 2018, he is the president of the International Court of Justice. I cannot read all his CV, otherwise we'll stay here for a long period of time. I'd like just to recall that he is the founder and general editor of the African Yearbook of International Law and of the African Institute of International Law, as has been recalled by Ambassador Sani, and he is a member of the Institut des Droits Internationaux. We are all extremely grateful for being here. President Yusuf, the floor is yours.
Thank you very much, Professor Nessi. A lot of things have already been said here today, and therefore I will limit myself to make some concluding remarks. But since a number of concepts have actually been thrown around and bandied around, it would perhaps be important to try to disentangle all those concepts. Dispute settlement between states and the protection of human rights are totally different things and should never be mixed. To take you back to the creation of the Organization of African Unity in the 1960s, one will have to remember that in 1963, when the OAU Charter was first adopted, the member states of the OAU did not actually include among the methods for the settlement of interstate disputes, judicial settlement of disputes. Why? Because they did not like to submit, and they did not want to submit the disputes among African countries to an independent judicial organ. No state in the world likes actually to submit its disputes to an independent judicial organ. One of the reasons is why the United Kingdom is trying to leave or exit from the European Union is because of the European Court of Justice. And they keep saying that they will no longer be actually subject to the judgment of the European Court of Justice. They want to be subject only to the judgment of the British Supreme Court. So, what do we mean by supranational African courts, and are there any supranational African courts? Are the REC tribunals, the Regional Economic Community tribunals, which have been evoked here, because there are 4 of them, the East African Court of Justice, the COMESA Tribunal, the ECOWAS Court of Justice, and the CEMAC Tribunal. Are these tribunals supranational courts? And what do we mean by supranational courts? I think that this should have been perhaps the first question to have been addressed here. And it's a pity that it has not been addressed. Because if you go to the treaties, it's possible that they may have some of the features of supranational courts, but actually they do not exercise any of the attributes of supranational courts. There is a very extensive degree of underutilization of those courts. So the reluctance of African states from the 1960s up to now to use judicial settlement of disputes has a direct effect and a direct impact on those courts. And then the question arises, why did this regional integration schemes in Africa create these courts if they did not want to use them? And I think this is something that should be addressed. Because when you enter into regional integration treaties, it is very difficult to say, I will not create an organ which settles disputes and which interprets and applies the treaty. Therefore, most of the regional integration schemes in Africa, as a matter of law, decided to establish tribunals that would interpret and apply the treaty. The East African Integration Treaty, the COMESA, Common Market of East and Southern African Integration Treaty. These tribunals were created to regulate, to interpret, and to apply the treaty. Therefore, the scope of their jurisdiction is very limited. And actually, it has been even limited further. If you take, for example, the East African Court of Justice as a matter of punishment, and in order to punish the judicial activism of the East African Court of Justice, the East African partners in the East African integration scheme have taken away some of the competencies of the East African Court of Justice and have given it to national courts. In the case of the East African Court also, and we will come to that in a minute, a protocol on human rights, which the East African countries were supposed to enter into and which was supposed to complete the competence of the East African Court of Justice, was never concluded also as a punishment of the judicial activism of the East African Court of Justice. So for African states, although they create these tribunals, they want the tribunals to stay where they are, to know their place, to know where they stand as far as the states are concerned. And this is where we come to human rights, because you create a tribunal, you don't submit any dispute between the states that have created the tribunal to the tribunal is underemployed. It's not doing anything. The judges are there twiddling their thumbs. They're waiting for cases, they don't get any cases. And then all of a sudden, they get cases on human rights. The only tribunal which is authorized under its treaty to receive human rights petitions is the ECOWAS Court of Justice. None of the others has actually the authorization under its treaty to deal with human rights issues. But what do? They are underutilized, they are sitting there, they receive petitions on human rights. They say, and that's what the East African Court of Justice said, the fact that there is a reference to human rights does not deprive us of our competence to deal with the rule of law and good governance. Rule of law, good governance are different from human rights. They are not human rights. But because the tribunal, the Court of Justice, wanted actually to deal with some cases concerning the member states of the East African Common Market or the East African Integration Scheme, it received human rights cases and it decided to act instead of being underemployed and doing nothing. This was the case also of the SADC tribunal. But in the case of the SADC tribunal, the punishment was severe. The tribunal was dissolved by the member states of the Southern Africa Development Cooperation Council. So, with respect to human rights now, and let's come to human rights, that's a different matter. So these regional courts are not basically competent to deal with human rights. They have to deal with the treaty governing the economic integration among the countries of the region concerned. It's only the ECOWAS that has the competence to receive cases on human rights, and it has been recently criticized for a judgment which it issued about a month ago concerning the assets of the widow of Sergeant Doe. Sergeant Doe was a military ruler of Liberia, and he made a coup d'etat as a sergeant and then proclaimed himself as Marshal Doe. He became head of state. He was the head of state of Liberia for several years. He was afterwards killed during the civil war of Liberia. The assets of his family were frozen by the state of Liberia, by the government of Liberia. She went to the ECOWAS tribunal and said that she had assets in Liberian banks of $18 million and that she wanted those assets to be freed, to be released by the state. And the ECOWAS tribunal said that this was her property and that the assets should be released to her by the state. The tribunal did not actually examine whether it was her property or the property of the state of Liberia that was misappropriated by Sergeant Marshal Doe, but they said it was a human right. So it was very much criticized for that, but it had a better record in the past because it had issued several judgments, especially judgments concerning slavery in Mauritania and the necessity to abolish slavery in Mauritania. But apart from that, the regional courts are not human rights courts by excellence, par excellence. They are not. They were not created to deal with human rights. The court that has been created to deal with human rights, and before the court, the organ that was created by the by the Organization of African Unity to deal with human rights was the African Commission on Human and People's Rights, and afterwards the African Court on Human and People's Rights. The African Court of Human and People's Rights has now a total of 146 contentious cases that are pending before it. And despite the fact that it does not have actually competence to receive complaints from individuals and NGOs, except when a state makes a declaration to accept such a competence. And only 10 states have made such a declaration And one of them, Rwanda, has already withdrawn its declaration because there were too many cases against it. So it withdrew its declaration. So there are 9 states that have now accepted the competence of the African Court of Human Rights to receive complaints from individuals and NGOs. And as a result of that, it has already received more than 202 applications for contentious proceedings, of which 146 are pending. It has also received 13 requests for advisory opinions, has already given 12 advisory opinions, has rendered 12 advisory opinions, and 1 request for an advisory opinion is pending. So the human rights in Africa is entrusted to the African Commission on Human Rights and African Court on Human Rights. And there, I must say, despite the fact that only 10 states have made the declaration, most of the African states, out of 54, 42 have actually ratified the charter. So most of them recognize the competence of the African Court of Human Rights and African Commission on Human Rights to deal with human rights. And there is no similar reluctance as far as human rights are concerned with respect to the judicial settlement of human rights cases as with respect to the settlement of disputes with regard to the settlement of disputes between states, because there it's more difficult. And as you know, of course, there are not too many courts at the international level or at the regional level in most parts of the world to which the jurisdiction to settle disputes has been entrusted by states. There are only 27, 28 European countries that are parties to the European Court of Justice is a basic document or statute. The only Court of Justice that was ever created in Latin America was the Central American Court of Justice, which died of disuse because nobody used it. And the only court that has had some success, apart from the European Court of Justice with respect to interstate dispute settlement, is the International Court of Justice. And it is only in the last 30 years or 20 or something years that it has had that success, because when I was a student and I went to The Hague, the court had no cases before it. So it's not only a phenomenon that is limited to Africa, it is a worldwide phenomenon, the issue of the reluctance to entrust dispute settlement to states. A final word with respect to human rights. I think that one has to be careful about characterizing one has to be careful about the distinction between colonialism and authoritarian regimes. Colonialism has nothing to do with authoritarian regimes. Hitler was not considered to be a colonial regime, Hitler's regime, nor was Mussolini's regime considered a colonial regime in Rome or in Italy. So al-Bashir's regime in Sudan is not a colonial regime, nor Bouteflika's regime is a colonial regime. They are authoritarian regimes. Colonization comes from the word colonization, colonizazione, which means settle and take over and control the land of others. And it was mostly a saltwater domination of peoples across the oceans, as you know. And of course, the right of self-determination as is spearheaded by the Pan-African movement from the 1900s, is a right to external self-determination, mainly. The African Union has now a charter on democracy and good governance, of course, which enables peoples to exercise internally also their right to self-determination in the Wilsonian sense of selecting or choosing your government based on the consent of the people. So the human right is what distinguishes the African continent as far as human rights are concerned, is the recognition of collective rights by the African Charter. There is no other international binding instrument or legal instrument which contains as many binding and collective rights as the African Charter on Human and People's Rights. It's not only, it does not only recognize the right to self-determination, it recognizes the right to a clean environment, it recognizes the right to peace, and it recognizes the right to development. And you will not find any of these rights in any other binding instrument at the international level. And this actually distinguishes the approach of African countries to human rights from the approach to human rights of other continents, especially the European continent, where individual rights are mostly given more prominence than collective rights. And of course, the African experience arises from the fact that not individuals, but peoples were colonized in Africa. And it is the right of peoples, therefore, that to emancipation and to development, which is given most prominence. And I think I should stop there. Thank you.
Thank you. Thank you very much, President Yusuf. Now, yes, there should be now a lot of time to discuss what we have heard. Unfortunately, the time doesn't allow us to do it, especially because President Yusuf has to leave he had to leave actually 5 minutes ago. I think that we have heard different opinions. Maybe we have also discovered positions we didn't suspect were those of their authors. However, I think that we have listened to very important contributions on, and maybe now we understand a little more certain issues that were either misunderstood or understood in a different way. I repeat, we don't have time, but I really would like to talk and to say something, but I think that we have just to respect the fundamental rights now of President Yusuf to leave, and I thank very much him. I thank very much all the participants to this workshop. Maybe we could try to gather the material and also the thoughts that have been presented today in a volume. So I don't menace, but I simply invite you to think about these. There are really a lot of things that should be explored more in depth. However, also, and I just stop on these last reflections of President Yusuf on the difference between collective rights and individual rights. I'm sure that he agrees with me that the fact that in the African continent there is a very strong feeling towards collective rights doesn't mean, of course, that individual rights don't have a stand. They have a stand especially in, within national borders, but maybe one day, if there are the right conditions recalled by Professor Senonjo at the very beginning, also other type of rights could have their I would say space for protection. However, thank you very much to everybody. Thank you to the participants, and we don't stop here. We will continue in the near future to deal with these issues. Thank you very much again.